Good morning, everyone, and welcome back to LiveLaw Academy. In this session, we are going to discuss a recent Supreme Court judgment that sits at the crossroads of judicial independence and judicial accountability. Yes, I am talking about the case related to Justice Yashwant Varma, which has been reported as Triple X versus Union of India 2025 Live Law Supreme Court 782. At the heart of it lies interesting set of facts. A fire at judge's bungalow, discovery of burnt currency notes in a storeroom, and then inquiry which led to the recommendation by the Chief Justice of India for the removal of the judge. Now, why this judgment is important for us? Isn't there a constitutional process to remove the Supreme Court and High Court judges? The answer is yes, there is a process under Articles 124 and 217 of our Constitution. But then there is also an in-house procedure. And that's exactly the Justice Yashwant Varma challenged before the Supreme Court. Its constitutional validity, its legality, and the action of Chief Justice of India to recommend for his removal by writing to the President and the Prime Minister. The questions before the Supreme Court were very interesting. The first question was whether this petition is maintainable, especially in the light of the fact that Justice Yashwant Varma participated in the inquiry. Then, what is the legal sanction behind the in-house procedure? Is it extra constitutional? Does it bypass the constitutional process? What is its nature? Then specifically, whether paras 5 and 7 of the procedure, whether they are constitutional. Para 5 enables the Chief Justice to make a recommendation to the Prime Minister and the President for the removal. And Para 7 makes it obligatory on the Chief Justice of India to disclose or to forward the reports to the authorities, to the appointing authorities. What is the status of these provisions, whether they are unconstitutional? Then lastly, whether the act of making the photographs and videos related to the entire incident, making public, whether such an act is permissible or impermissible under the procedure. Now, before we understand how the Supreme Court has answered these questions, we must understand, or rather there is a need to understand certain basic foundational things first. Our Constitution provides a clear provision regarding removal of High Court and Supreme Court judges. One may refer to the text of Articles 124 and 217 and 218. They deal with the impeachment. And the process is kept deliberately tough, deliberately difficult. It starts with a motion in either house of the parliament. And if that motion is passed, then an inquiry is conducted under the Judges Inquiry Act. This inquiry is conducted by a body comprising of a Supreme Court judge, a High Court judge, and a jurist. And this body has to, ensure that principles of natural justice are respected. Evidence will be disclosed. It will be shared. Opportunity will be given. Witnesses will be examined. Opportunity will be given to the judge in question to make a defense. All these things. And then there will be a finding. And if the charges against the judge are proved, then only Parliament can proceed further. And if there is a finding that yes, charges are proved, Parliament then has to pass a resolution by special majority. And then the final order, a written order, has to be made by the President, closing the entire proceedings. But the Constitution is silent on any measure that is short of impeachment. It does not talk about any in-house procedure. And because of this silence only, the in-house procedure evolved by the judiciary in the year 1999. What is the nature of this in-house procedure? The nature is, it is just a fact-finding exercise. The intention is not to replace the impeachment process. It is just a fact-finding exercise. That is the nature. Now let's come to the answers given by the Supreme Court to the questions that I just highlighted before. The first question as to the maintainability. The Supreme Court said that Justice Yashwant Varma participated in the inquiry. So what happened? There was, when the news broke out, the Chief Justice of the Delhi High Court sought an explanation from Justice Yashwant Varma. He responded by stating that neither he nor his family members kept any cash in that room. But his response did not end the matter, did not bring any closure to the matter, and in-house procedure was triggered. The committee conducted its inquiry and came to a conclusion that there was a serious misconduct. On 8th May, there was a press release stating that Chief Justice of India has forwarded the report of the committee to the Prime Minister and the President, recommending the removal. Then after 2 months, on 17 July, Justice Yashwant Varma filed a writ petition before the Supreme Court. So the first question was regarding the maintainability. The Supreme Court said that Justice Yashwant Varma participated in the inquiry. He had no objections whatsoever. Only when inquiry went against him, he decided to challenge the very jurisdiction of the committee. He decided to challenge this in-house procedure. The Supreme Court clarified that yes, fundamental rights under our constitution cannot be waived. That is a settled position. But then there is also a settled position that the conduct can also become relevant. If your conduct is questionable, then relief can be denied to you. And here, Justice Yashwant Varma's conduct did not inspire confidence. But the Supreme Court did not dismiss the petition outright. It decided to answer the rest of the questions. The second question was, what is the sanction behind this in-house procedure? Whether it's a law or just an internal mechanism, which is directory in nature. What is the legal backing behind it? So the Supreme Court analyzed certain previous decisions. In the light of those precedents, it was found that there were discussions regarding this in-house procedure, and it was upheld in those decisions. And when that was done, now this in-house procedure is the law under Article 141 of the Constitution, which declares that, which provides that the decision of the Supreme Court becomes the part of the law of the land. So by that way, it had legal backing, though Constitution does not talk about it, but legal precedents made it the law of the land through Article 141 of our Constitution. Then coming to the constitutional validity of paras 5 and 7. Para 5, which grants the authority to the Chief Justice of India to make a recommendation to write or forward the report to the President and the Prime Minister. The Supreme Court analyzed it. it came to the conclusion that the Chief Justice of India is not expected to be a silent spectator. The Chief Justice of India is not expected to be just a post office. Being the administrative head of the judiciary, it is his responsibility to communicate any adverse findings against the judge found in such inquiry that was conducted to the appointing authorities. It is his duty to do so. So there was no problem with para 5. Para 7, which makes it obligatory on the Chief Justice to forward the report. It was argued on behalf of Justice Varma that such a step in the entire scheme of things can cause prejudice against the judge concerned. Also, it's a violation of separation of power. The Supreme Court, highlighting the nature of the in-house procedure, we discussed it. I have just told you that what is the nature of in-house procedure? It does not bypass the constitutional mechanism provided for impeachment. It is just a fact-finding exercise. So, the very nature of the in-house procedure is such that it nowhere comes in way of the constitutional process as envisaged by the framers of our constitution. As far as separation of power is concerned, since the parliament is not bound by the opinion of the committee and the recommendation of the Chief Justice of India, there is no question of separation of power being defeated. The rest of the things under 124(2)(17) and Judges Inquiry Act, they will go as it is, because the report of the committee through in-house procedure cannot remove the judge. As simple as that, right? So for both paras 5 and 7, it was found that they are not unconstitutional in any way. Then the last question regarding the publicity of photographs and videographs. The Supreme Court said that yes, it should not have been done. The procedure nowhere provides such a step to be taken. In fact, the procedure has to maintain the secrecy. But unfortunately, these things were published. But at the same time, the Supreme Court said, only because of this fact, the report of the committee cannot be ignored or cannot be thrown out completely. Only because of this fact, the committee's report cannot be declared invalid. So, first thing is, the procedure is not unconstitutional. Second, the act of the Chief Justice in forwarding the report and making a recommendation was also not unconstitutional. And thirdly, the secrecy has to be maintained. This is another last takeaway from this judgment. The secrecy had to be maintained. Now, where does all this leave us? We have to appreciate, we have to understand that this judgment is not only about a personal battle of a judge. It also brought clarity about the nature of in-house procedure, about the legal sanction behind it, about the authority that can be exercised under the procedure, the effect, right? And its relationship with the impeachment process envisaged under our constitution. So that was it for today's session. If you found this valuable, then please subscribe so that you do not miss any such discussions in future. Because if there is any complicated judgment or legal development, we will deal with it and you will be able to understand not only the what, but also the why behind it. Thank you very much for watching. See you in the next one.